Okay, I think we can get started. Rob, are you ready?
I am ready, Charles.
All right, let's get to it. Welcome everyone, wherever you are joining us from, to today's webinar on GDPR, a competitive edge for MSPs. We are going to be tackling some very complex issues today, but we're going to make them very understandable, or at least more understandable than they typically are. We're going to be looking at the General Data Protection Regulation, or GDPR as it's more commonly known, and providing you with some helpful analysis on what GDPR is about, what it means for managed service providers and other types of IT providers, and providing some both legal, technical, and business solutions and helpful hints on how you can navigate the world of GDPR and commonly requested questions or concerns or demands from your customers or their customers as it pertains to GDPR. So we will have a Q&A session at the end. You can ask myself or Rob any question you'd like as it pertains to GDPR. And but if you have questions, certainly feel free to let those be known in the question area on the right side of your screen. So next slide. GDPR, you know, this thing has been coming for a number of years, and it became enacted, or it became active, shall we say, this year, I believe in May, and a lot was made out of it. A lot is being made out of it, and in my opinion, Rob may have a different opinion, but I think that there's a lot of people who know very little about GDPR and what it really means. This is kind of similar to Y2K, right? Everyone has an opinion and everyone has something that they can sell to somebody else to help explain this issue, but it is a complex issue. It crosses both legal as well as business, technical, data privacy issues. So it is unique in that one regard and makes it slightly different than Y2K and some of the other issues that we've faced as a technology community. But basically, I wanted to give you guys a quick overview of what GDPR is and what it means for MSPs. Next slide, please. So some highlights. What does GDPR mean? What was it designed to do? Because that's really, when you get down to it, it's a law. And the law, as every law does, it has a purpose. It was written for an express purpose. GDPR was designed to combat the prevalence, the hegemony, if you want to call it that, of public, I would say US public cloud providers. It was not designed to regulate directly or indirectly your average everyday managed service provider. This was going on, the discussions for GDPR for several years. In fact, MSPAlliance and some of its board members were involved in some of the early discussions with the EU representatives, and they were very concerned about data privacy. European data privacy is at the core of what GDPR is expressly about. But it's important to know that it's not designed for you as an MSP. It was really designed for those larger public cloud providers like Google, like Facebook, like Amazon, like Twitter, social media, but also just larger public cloud companies. The focus was undoubtedly on protecting European data, to carve out a zone of protection for Europeans so that they could know that their data was safe and it was secure, and that only approved or well-known organizations were accessing it. It is a law in a traditional European sense, and so it is full of lots of red tape, lots of regulatory requirement. It is also inclusive of some financial penalties. What the European law would be complete without a financial penalty attached to it. And GDPR certainly does have financial risk associated with it. We'll talk about that later on. And here's the catch-all. Most people, most MSPs that I talk to, and Rob may have some input on this as well, view GDPR as, what does it have to do with me as a non-European company? I'm a non-European MSP. I'm in Canada or I'm in the US. Does it apply to me? It shouldn't apply to me, right? It's a European law. It doesn't apply to the United States. It does. And we're going to talk about that in much more detail, but GDPR can and does impact even non-European MSPs in some very real, meaningful ways. And it does not mean that every non-European MSP should be concerned about it, but for a number of other reasons, which we will also tackle later on in this webcast, it means that you as an MSP, wherever you are in the world, but especially if you have European customers or customers that have European data as part of what you are managing as a managed service provider, it means you at least have to be aware of the law. You have to be aware of what it means. You have to be somewhat conversational in terms of what it means so that you can talk intelligently with your customers and at least be able to say why the law does not apply to you. And I think that should be a minimum bar for understanding for GDPR. For taking, a takeaway from this is, yes, it does apply to me. Great. How do I respond and next steps? We'll talk about that. But even if it doesn't apply to you, this is a very helpful webcast for you to understand why it doesn't apply to you, so that when your customers come to you and say, "You're my MSP, I'm concerned about GDPR. What can you tell me about how you are GDPR compliant?" you can answer intelligently. And that's one of the other takeaways that we hope that you'll get from today's webcast. Next slide. It is a law, and like any other law, it has burdens, right? Hurdles that are being placed in front of an MSP and its customer base. But like any hurdle, it can be an opportunity. And I certainly do view GDPR as something that could be turned very easily into an opportunity for MSPs. And here are my thoughts on how some of those things can be turned into opportunities. As a differentiator for managed service providers, GDPR could become an area of expertise. Not that dissimilar from how MSPs early on became experts at financial services firms, providing managed services to banks, hospitals, medical practitioners, insurance companies, legal practices, accounting practices. Each of the vertical areas of expertise within the managed services profession have some sort of regulation behind it, and GDPR is no different. So it becomes an area of expertise, of specialty, and as a result, it could become a differentiator, a very real, meaningful differentiator for your MSP practice. It can provide additional revenue. We'll discuss that in a few slides, but there are some very real ways that you can extract additional revenue from your customers by selling them services, maybe even existing services, but that happen to be tailored to GDPR customers or GDPR data. We'll talk about that in a little bit. I certainly believe that if you are, if your practice is governed or comes underneath GDPR, that you should be able to price your managed services higher. I think that that's true across the board for many, if not all, of the other regulated vertical markets. We tend to see those MSPs pricing themselves higher than the average MSP, a general practitioner, for example. And so I think GDPR focused or MSPs that have a GDPR practice could very well charge a premium for those services because of the unique nature of those risks that are placed on the MSP and their customers. GDPR certainly could become an area of adding more services to your managed services practice. For example, it could be a cross-sell opportunity for consulting. It could be re-architecting the way your customer handles data to become compliant with GDPR. So there's a number of things both within your managed services and your consulting and maybe other professional services portfolio offerings that could become relevant with GDPR. Lastly, and I think that this is just a good thing that MSPs are increasingly being required to do, regardless of whether you are in Europe, whether you have a European customer or not, and that is just becoming more familiar with the type of data that you are being asked to manage. If there's a general theme or lesson to be learned from MSPs over the last three or 4 years, it is your customers can cause problems for your managed services practice, depending on what they are asking you to manage, what types of servers, what types of data they are giving to you to manage. These things are greatly important. They greatly impact your risk. They greatly impact or should impact how much you charge for your managed services. And so the first part of that understanding is knowing the type of data that your customer is giving to you to manage. And that's certainly very much true with GDPR. Next slide. So I alluded to this earlier, which is GDPR really does force managed service providers. It forces too strong a word, and it heartily encourages MSPs to better understand their managed services offerings and what they're delivering to their customers, because what you deliver and how you deliver it is very much part of your compliance or lack thereof with GDPR. GDPR does force, it is a requirement that if it applies to you, then you need to have a better handle on your risk mitigation policies and strategies as an MSP. These certainly apply to customers, end user customers of yours, but it also, in many cases, will apply to you as a managed service provider and how you are viewing your risk. It is absolutely, and this is not unique to GDPR, but it is something that is called out specifically in GDPR. Vendor management is now front and center for MSPs. If you are an MSP and you are going through a SOC audit, if you are an MSP and going through an MSP Cloud Verify certification review, those and other types of standards or platforms along with GDPR all focus on and accentuate the need for MSPs to have very good vendor management. What do we mean by vendor management? Think of it as you're taking a managed services offering to market. Who, in addition to your MSP company, who are you taking along with you to deliver those services? What we mean by that is data centers, cloud providers, third-party external service providers, contractors, anybody and everybody who is touching the customer data or infrastructure. People want to know. And that is what we mean by vendor management. And that's very critical to being compliant with GDPR. Certainly GDPR, and we are going to talk about this in great detail shortly, it's forcing MSPs of all sizes to take a look at their contracts, take a look at the type of insurance that they have, and to make sure that they have up-to-date agreements in place with their customers, agreements that are accurately reflecting their relationship as it pertains to GDPR, and also that they have appropriate insurance to address their risk. The type of risk that the MSP is taking on with GDPR customers should be addressed in the type of insurance that you are acquiring. Next slide. So with this, I'm going to stop talking and I'm going to turn it over to Rob, who's going to give you a much deeper dive into some of the specific definitions and requirements that GDPR has laid out for us. And he's going to give us his expert view on this. And Rob, take it away.
Thank you, Charles, and we'll hear more from Charles in a few minutes, but I wanted to take some time to look at the actual language of the GDPR and explain to you why, in many ways, I think it is very different than privacy legislation that we've seen in the United States and some of the challenges that my managed services clients have faced in dealing with GDPR. So first, you know, in the United States, we have a concept of personally identifiable information that is very narrow. In GDPR, personal data, which is the data that's subject to regulation, is much broader than anything that we've seen in any significant U.S. regulation. And it includes things like an online identifier. So, you know, a screen name for social media is personal data under GDPR, whereas that would not be personally identifiable information in the U.S. One or more factors specific to physical, physiological, genetic, mental, economic, cultural, or social identity. These are all sort of demographic factors that under U.S. law would not be personally identifiable information. But you can see, as written here, this is extremely broad. Really anything that can be used to identify a person is personal data under GDPR. And so we can't use the same old analysis that we used in the past when, you know, we take the position that there's no PII being managed or stored, and therefore we don't have a privacy or security concern that arises from regulatory requirements. Under GDPR, we have a very broad definition of not only the data that is being regulated, but as is germane to MSPs, the question will arise, are you processing under GDPR? Because if you're processing personal data of your customers under GDPR, then GDPR applies to you. And therefore, you have to be compliant with all of the requirements of the controller, as if you yourself were being regulated under the statute. And processing has a very broad description. And it includes collection, recording, organizing, structuring, storage, retrieval, consultation, use, or otherwise making available. Certainly includes hosting. Most definitely would include most managed services where the data subjects of the customer include European data subjects. So the problem with many MSPs is not answering the question of whether or not their services constitute processing, because in many instances, in virtually all instances, the answer would be yes, as this is a very broad definition. The question arises, is there any EU data subject data being managed by the MSP? And in many instances, they don't know whether or not their customers offer goods and services in the EU, or whether there's EU data within the applications that are being hosted or managed. And that puts us in a very difficult problem. where we either have to take the position that we don't process, as that term is defined, GDPR data for controllers, which would be, in this context, your customer. Assuming you're an MSP that doesn't offer goods or services in the EU, the only question you have to answer is, are you a processor? The controller would be your client. The controller is the one who owns the relationship with the end user. So if you think about it in the context of the question being whether or not your clients are controllers, as that term is defined under GDPR, and if they are, you are likely a processor. If they're not, you're not a processor, and GDPR likely doesn't apply to you. The challenge is, do you know exactly what the data is that your clients are managing or controlling? And the answer for many MSPs and cloud solution providers is no. And that creates a significant challenge. So a processor is an organization that processes personal data on behalf of the controller. And now we say, am I a processor? Well, is there personal data involved? Given that broad definition, most likely yes. Is the conduct that I'm engaging in constitute processing? Given the broad definition, most likely yes. So the question is, does the client have any EU data? They may not know. And GDPR compliance is like being pregnant. You either are subject to the regulation or you're not. There's no de minimis standard where you do this customer only has 5 EU clients and therefore it doesn't apply. You're either in or out for GDPR. And this is where you come to the dividing line for managed services. Because if you're in, you've got a heck of a lot of restrictions that you have to deal with. This chart here shows you some of the things that you have to implement. And you can see we've annotated this slide with the actual provisions of the regulation. But this is akin to being subject to HIPAA or subject to GLBA, which is the financial regulations in the United States. If you're an MSP for banks, you're subject to banking regulation. If you're an MSP for hospitals, you're subject to HIPAA regulation. If you're an MSP for customers who do business in the EU and have EU personal data within their systems, now you're subject to all of these rules related to being a processor. So you want to ask yourself the question, am I a processor? And if I am, I've got a regulatory initiative that I have to embark on, which, as Charlie had pointed out, will be a differentiator in the marketplace because there will be many customers. And as you dig into this, what you'll learn is many small customers are subject to EU. I mean, my little 5-lawyer firm in Texas has clients in the EU. One of our largest customers is headquartered in England. We have large clients from Italy and other European markets. And as a result, we can't just put our head in the sand and say, oh, we're a Texas-based law firm and therefore these rules don't apply to us. Because it doesn't matter where you are when it comes to processing of data. The question is only what is the data that resides on your client's system? And if you don't know, I think you have to assume that there is or could be EU data. And if you do know that there's EU data, then you have to comply with the regulations related to processing. So what can you do to flesh this out? You know, one of the most common engagements that we have and have had over 15 years with MSPs is a discussion about customer contracts. And so how does this GDPR regulation impact the issues of customer contracting? Well, one is for those MSPs who want to take the position that they will not process EU data, they will not be compliant with GDPR. We have some drop-in language for our contracts that basically say to the customer, you will not ask us to process EU data. You represent and warrant that you're not a controller, as that term is defined under GDPR. And you agree to indemnify us and hold us harmless to the extent that we are called on for any harm in terms of regulatory or otherwise associated with your failure to comply with this provision. That is an option. And what I like about it is it will require your customers to say, hey, wait a minute. We do have EU data. We are concerned about GDPR. And if that happens, then you have to go down the next level of discussion, which would include a compliance program for you and data processing agreements with all of your customers that have GDPR compliance needs, and sub-processor agreements with all of your vendors that would be compliant with GDPR as well. And so if you think about the question of are you in or out for GDPR, it's a significant question. It is a big step to implement a GDPR compliance program. There are a number of things that you have to do to maintain such a program, and it comes at some cost, both outside cost and internal cost. So if you don't want to do business with EU customers, then you can take the position that you won't, and make that clear in your contracts. What I have found is that it's too risky to only do business with customers that have no exposure to GDPR, and that for most businesses, implementing the GDPR compliance program will be a differentiator in the marketplace for the reasons that Charlie has mentioned. Those that know that they need GDPR compliance will only shop among MSPs that make them feel confident that they have the ability to offer the services. And those more sophisticated providers that have implemented GDPR solutions and can talk, the specifics with the customer, not only around what they're doing as a processor, but assist the customer in meeting the controller obligations, will be in a much stronger position relative to the competitive market. But you have a choice to make, and it's a choice of being either all in or all out on GDPR compliance. And for the vast majority of my clients, I'm recommending that they implement a GDPR compliance program that they then can use as a way to attract those clients that will increasingly become aware of and increasingly requiring a demonstration of compliance with GDPR from their vendors, which would put you in a competitive advantage over those that are late to adopt or choose not to adopt. So with that, I'd like to bring Charles Weaver back into the conversation so that we can talk about some practical next steps.
Absolutely. Thank you, Rob. And that's tip of the iceberg. I mean, what Rob gave you is the meat and potatoes of GDPR understanding. I heartily recommend any of you, especially on the MSP tech landscape, looking for this type of legal advice to contact Rob and his firm. But this is something that, for reasons that we'll explain shortly, I think there are reasons for you to contemplate becoming GDPR compliant, quote unquote, because you are going to be complying with certain elements of that anyway from many of the other laws that exist here in the United States and Canada and elsewhere. It just may not be the complete GDPR workup, but you're going to be asked to do things like, data breach, like vendor management anyway for other areas and other customers. So why not just do the rest of the way and get there? Next steps. What do you practically need to do in order to become, and I don't like to use that term GDPR compliant, but what do you need to be ready for GDPR? Depending on whether you are classified as a processor or not, the role of having a data processing officer is something that will come up. Even if you are not, you may be dealing with customers who are forced to have their own data processing officer, and you may need to work with that person in their role of maintaining GDPR compliance with you as a vendor of that company. Rob, I don't know if you have any comments about that, but I mean, it's not for everybody, but it could apply to some MSPs, even those outside of Europe, correct?
Yeah, so I think this is an important thing to think about. Once you decide that you are subject to GDPR, one of the important questions that you need to ask yourself is whether or not you are required to designate a data protection officer. Article 37 of GDPR is what controls, and essentially what you're looking at is the one that I think you want to look at the most is under 1B. The core activities of the controller or processor consist of processing operations which by virtue of their nature, their scope, and or their purpose require regular and systematic monitoring of data subjects on a large scale. Or C, the core activities consist of processing on a large scale of special categories of data under Article 9 or personal data relating to criminal convictions or offenses. So I think for most MSPs, we're talking about Article 37, 1B. And the issue is, are the processing operations, are the core activities of the MSP or its client require regular and systematic monitoring of data subjects on a large scale? If the answer to that question is yes, then you need a DPO. If the answer to that question is no, then you don't. And again, I know I went through that quickly. For those of you who are interested in looking at this more closely, it's Article 37, 1B would be the area that I would focus on for this question.
Yeah, so a good answer. Go read it yourself if you're curious to see whether DPO applies to you. I look at this as they want to know who's responsible and who to go to if there's a GDPR violation. I mean, that's my quick non-technical, non-legal view of why they want a data processing officer being named. Is they want to know who to go and ask questions of. You should have an internal risk analysis process. You should have an internal risk program. Every MSP should have this to certain degrees, right? Different levels of maturity, different levels of completeness, but every MSP should be looking at internal risk and how they manage it. These are basic questions that the end user community are asking and have been asking for many years. In this case, it came with a very bureaucratic law, much of which I personally don't agree with, but here's one good thing that they legitimately have a right to know, which is, look, we're outsourcing the management of our data to you as an MSP. How do you handle your risk? It's a fair question, and it's demanding of a fair response. The third bullet point here is, are you tracking your data processing activities for European data? This, for me, crosses the line or straddles the line of something that's more bureaucratic. I know most MSPs have a lot of data that they sit on, through their monitoring platforms, trouble tickets, etc. Could you as an MSP tell someone, what you are doing with precise types of data that you manage? Some of you would say yes, others probably might say no. Rob, I don't know if there's any clear guidance yet on just other than tracking processing activities.
Yeah. So if you look at Article 30, it's a section entitled Records of Processing, and if you slide down to subpoint 2, it deals with the processor's obligation to maintain a record of all categories of processing activity carried out on behalf of the controller, and it gives you a list of what those records have to contain. They have to be in writing. They can be in electronic form, but they require the name and contact details of the processor or processors and each controller on behalf of which the processor is acting. The categories of processing carried out on behalf of each controller, where applicable, transfers of personal data to third country or international organization, including the identification of a third country. Where possible, a general description of the technical and organizational security measures. So if you look at Article 30, it gives you some guidance on the nature of the records of processing that you're required to keep as a processor under GDPR, and I would focus on that. And then, Charlie, just going back to the question on risk assessment, just to give some pointers on where that is, if you go to Article 35, it talks about the data protection impact assessment and what kind of risk analyses are required. And so for those of you who are thinking about, do you have the internal risk analysis processes that are required, reference to Article 35 and data protection impact assessment will help you determine if what you're currently doing meets the requirements of GDPR.
Excellent. So you have some homework out there if you want to take a further, deeper dive into those 3 bullet points. I think you should. I think you should actually take those articles that Rob referenced and read them for yourself, because it's good for you guys to be familiar with it. The last bullet point is really just about getting back to your internal risk. Do you know your customers presenting GDPR compliance or risk to you? It's easy when your customer comes to you, and I'd say it's easy, but I've heard a lot of MSPs who have said, hey, we are interested, in the context of their audit or their certification, we were asked by a customer about GDPR. In many cases, I've learned that the customer may not even be at risk of or covered by GDPR, but they're just asking because it's coming to them from someone else, maybe a compliance officer, it could be a legal officer. This is such a prevalent question. It's a question of, does this apply to me? Does it apply to you? And they just want to find out who's responsible, who's got the hot potato. Remember that game. So knowing who your customers are, start certainly with the customers that have a physical presence in Europe. That would be an obvious telltale sign. The less obvious are the customers with offices not in the EU, but who have nonetheless a presence there. Maybe they have customers there, users in an EU country, which would make them and potentially you subject to GDPR. Just important things to know about your customer base. Next slide.
Let me jump in here, Charlie, with one reference. So Article 3, entitled Territorial Scope, will really help you answer the question of whether or not your clients are GDPR clients. It makes the point that the regulation applies to the processing of personal data in the context of activities, regardless of whether or not the processing takes place in the EU or not. And it has essentially two principal criteria. One is the offering of goods or services in the EU, subject, what I mean by offering, it could be a customer's website is available to EU data subjects and they can make purchases online. That's offering goods or services in the EU, even if it's a small percentage. The other criteria is the monitoring of behavior, as far as behavior takes place within the union. This one is a really big problem because anyone with a website that uses cookies that's available in the EU is monitoring behavior of EU data subjects through the use of those cookies, and therefore is subject to the regulation. That's why you see a high prevalence of sites now with cookie management applications to comply with the cookie consent rules of GDPR. The other option is to make your website not available in the EU, which many of my clients have decided is a risk they don't want to take. So when you start thinking about, do you have GDPR clients, any client with a website with cookies that's available in the EU is a GDPR client. Any client that offers goods or services in the EU is a GDPR client. And you can, again, reference to Article 3 entitled Territorial Scope.
Yeah, good points. Again, this is more back to Rob's point of getting your contracts reviewed and updated. You got to know what your agreements say, and this has been a struggle for managed service providers for the last 10, 15 years. I think we've been making good, steady progress, but here is now a very real, widespread reason for why you should have not just downloaded from a template, not from the web, and you just swap out your company name, but you actually had someone who knows this stuff review your existing service contracts and update it not only to what you do, but with an eye towards protecting yourself and your customers from GDPR. Rob, I know you got a lot to talk about on this, but any quick pointers or highlights that you want to mention?
Well, yeah, I think that, the key document here that it comes into play is called the data processing agreement. The acronym is DPA. And what you see is, as an MSP, you may have clients sending you their proposed DPA saying, we're subject to GDPR. If you want to work with us, you've got to sign our DPA. And then in other instances, you'll need to propose DPAs to your subcontractors and to your customers who are subject to GDPR but may not have proposed an agreement to you. The question of a written agreement is not optional. The data processing agreement has to be in writing. And anytime you're engaged in processing activity for a controller, the details of your data processing agreement have to be in writing. One of the things that we're seeing in the market is that customers are going to MSPs and saying, we need you to sign this for GDPR. And what it really is a complete overreach and an attempt to, for example, renegotiate the terms of a master agreement, including key things like risk balancing and other aspects that are not required by the regulation. So what we have been doing for our clients is not only drafting data processing agreements for them to use for their customers that require them, but also reviewing proposed data processing agreements that are sent from MSP's customers to make sure that they're not overreaching in what they're saying is required by GDPR, but in reality, it goes way beyond that and constitutes an attempt to renegotiate things that should be in the standard customer contracts, including, for example, risk balancing terms that would be in a managed services contract or a master services agreement.
Get your contracts reviewed. I think that's a good quick takeaway. The next point, vendor management. This is a larger scale review that most MSPs, if you're in a SOC 2 compliance audit right now, if you've gone through an MSP Cloud Verify audit, you know about this because you've had to do it. It's part of that standard. But this is larger speaking. This is about who are you authorizing to touch our data? That's what that question is about. Who are you as an MSP, and who are the people that you're bringing? Who are your vendors? And that's a very rational, plausible, realistic question to be asked. And if you don't have a good, succinct answer, they are likely, the customers, their compliance officers, their users, their overseers are going to justifiably say they either have something to hide, or more likely they just don't know, and therefore they pose a risk to us, because not knowing who your vendors are now is a liability to a customer who says, I have to be very transparent to people, including a GDPR regulation, and I have to transmit that information and perform my own risk assessment based off of the MSPs that I'm using. So it's about transparency as I see it, and having a good vendor management program, knowing who your vendors are and doing due diligence on them. Again, it's part of what we cover within the MSP Cloud Verify, as well as SOC 2. It's important to know, and if you're not doing it, you need to start. It's that important. Any comments, Rob, on vendor management?
Yeah, so the other thing to think about is, to the extent that your vendor is a sub-processor, as that term is defined in GDPR, you need to get them signed up to a data processing agreement as well. And so, as part of your vendor management program, you're going to need a data processing agreement process to ensure that all of your vendors that are intersecting with GDPR data are signed up to an appropriate data processing agreement, which is a requirement to use them as a sub-processor under the regulation.
The third bullet about reviewing your product offerings in light of GDPR, what we're really talking about is a service catalog. We're talking about a line card of the types of services that you as a managed service provider offer. And I know a lot of MSPs have tended to shy away from doing that, but I think it's really helpful, because what it would allow you to do is to assess which product offerings, which managed services product offerings you are taking to market might be applicable to a GDPR customer and which may not be. I'm talking specifically like hosting, right? If you are providing hosting or co-location services to your customers, that would be a very natural thing to say, okay, this is something that we have to that is going to become GDPR suspect or brought up within the light of GDPR, meaning a customer might reasonably say, we're going to host with you. Where is your data center? Who are they? Who do they allow access to touch our data? Those are very natural questions, and you could actually create a line card that has those questions or answers built right into them, so that your sales and marketing and compliance people could be very quick to respond to those types of compliance questions. Same with your risk exposure and your pricing. I think that, as I said earlier, if you're doing business in GDPR country with GDPR customers, it is completely fair to revisit your risk and also revisit the pricing of those services to those GDPR customers. Rob, I mean that's kind of an old standby, best practice for MSPs in vertical markets. I think it equally applies here.
I agree, and Charles, you made the point earlier, which I agree with, that we've seen a trend already with major regulatory frameworks in the United States, including HIPAA in the healthcare context, GLBA in the financial services context. And what we've seen is that those providers that focused in on those verticals were able to command premium pricing, not only for services relative to their peers that weren't in those vertical markets, but also fetching much higher multiples when they go to sell those businesses. And so I definitely think that a GDPR focused service, a GDPR managed service provider that is comfortable talking to clients about the regulation and can convince clients that they have a suitable solution for the client's concerns related to GDPR will be in a position to command premium pricing for services, as well as premium multiples in the event of a sale or other business transaction.
I agree, absolutely. Supplementing your assurance. You need to do this. This is a obvious one. This is a don't forget about this one. We did not talk about it, but it has been already broadcast pretty vocally and visibly out there, the financial risks of GDPR, and I'll go through them real quickly. One is the regulatory fine, which I think it's the greater of either 4% of your gross revenues. Correct me if I'm wrong, Rob, or an alternate number, but it's the greater of those two, and those could be very, very high, significant amounts. And then there's a right of private action, which is the ability to sue. And although I wouldn't necessarily call Europe a litigious land, maybe this is something that will change. But even if it doesn't, I have a feeling that there are going to be plenty of non-European law firms getting involved in suits involving data breaches and data security incidents. And if you are not protected both legally with your contracts, as Rob alluded to earlier, but if you don't have the right type of insurance, you could be at risk. So look at your existing insurance coverage, make sure that it is protecting you against these types of compliance activities, and be protected.
The other point to think about there is, talking to your customers about insurance on their side. I mean, there could be, your professional liability insurance, which is what we're talking about here, will cover your customers in the event that your negligent acts result in some sort of a regulatory or financial imposition on your customer. But as you know, there are many things that could happen to the customer in terms of their data that would not be due to a negligent act on your part, but that still could cause injury. So, for example, a negligent act by an employee, an intentional act by an employee, a criminal act of a third party. So there are many areas of risk for your customer that your professional liability won't answer for. And so speaking to your customer about first-party cyber liability insurance is a good idea, because it not only helps the customer mitigate the risk, but it also explains to the customer the extent to which your insurance is going to apply in the event of an adverse claim. And so the insurance piece is both to look at your professional liability and also to counsel clients about their need for cyber liability insurance independent of what you're bringing to the relationship.
And the final bullet point is, I'll make it very quick, which is the EU is already working on a regulatory, I should say, a certification scheme, so that the providers of technology services can be certified and more transparent. And that is something that's happening now. It's going to happen and evolve over the next several years. But suffice it to say that the act of becoming certified or audited is going to be very critical. It already is in certain regulated industries, vertical markets here and elsewhere in the world, but now Europe has thrown its hat into the ring, and it's going to be very important there as well. What we're talking about simply is a means of easily disseminating information on your compliance with GDPR and other types of regulations, so that you can effectively communicate how you handle certain things to your customers. That's what a good certification program should do. Certainly, we are seeing a big uptick in that, and it's going to only increase over the next several years. Next slide. We don't know yet, and we're trying to get some time in here for some questions, but we don't yet know how far or pervasive GDPR is going to reach. But right now, I think it's safe to say that everyone's talking about it, and that these are very practical, real world, non-scary, right? We're not trying to scare you. These are very realistic scenarios that we're presenting today. The financial penalties, I don't think that there have been any assessed to date, but once we start seeing those, including the civil litigation, I think that we're going to have a much better idea of what the financial risk is. Rob, you and I have talked about this. I think it's just a matter of time before we see either a penalty or a lawsuit emerge related to GDPR.
Well, I would tell you that, to your point earlier about the purpose of the legislation, the day after it became effective, a lawsuit was filed against Facebook under GDPR and another one against Google under GDPR on the very first day. So those cases are winding their way through the process. And again, just because those providers would be implicated or sued doesn't necessarily create a risk for a US MSP or its clients that are, not, large public cloud providers. But I suspect that over time, we'll see a number of additional enforcement activity related to the regulation. And I think that it is an evolving risk landscape. And that's where we come back to the insurance, because, anytime you're in an evolving and yet unknown risk landscape, insurance products can really help to fix your cost associated with that unknown risk. And so that's why we're recommending, in addition to implementing the basic compliance initiatives that are clearly identified in the regulation, to mitigate some of these unknowns with insurance. Absolutely.
I want to take some time because I think the next slide might be our last one. Wanted to take some time, and we'll send out contact information for both myself and Rob. If you have questions, we'd be happy to answer them. Do you guys have any questions? Anything that you heard today that you would like to raise? Certainly feel free to raise those within the question area. It's a lot to take in, and certainly we're learning more and more about it. Rob, I think the fact that Google and Facebook were the very first ones to see a legal action reinforces what we said very early on, which is this law was aimed at them, not them only, but those types of public cloud companies who have been, accused of taking and using data in some very inappropriate ways. We don't have to get into that, but that certainly does support that, why GDPR came about in the first place.
Well, I agree with that, Charlie, and I think it's like all regulations, right? You start out with an intent to go after sort of the bad actors that everyone would agree is a bad actor, but in the end, it creates a regulatory burden for non-bad actors, and there's a cost of compliance and a cost of doing business under this, what I would consider a very invasive, very broad, very overreaching regulatory regime that has a lot of unanticipated consequences and affects many businesses that aren't really within that target. And so while I agree it was originally targeted at them, they did a very poor job, I think, intentionally, of limiting it to those types of companies. There are no, they could have done a lot of things to make it more specifically targeted at them and to exclude smaller players, but they've done nothing of that nature to ease the impact, both in terms of the reach and the burden associated with this regulation.
Because we've gone over the 1 hour limit, we appreciate everyone's time. If you have questions for Rob or myself, feel free to reach out to us. This webcast will be available after for viewing, and hope you got something valuable out of today. Rob, appreciate your time and help in putting this together.
Thank you very much. Have a great day.